Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, listen, there has been some action going on back in the D.C. Circuit Court, and most of it went unnoticed because many of us were all spun up about forced reset triggers, pistol stabilizing braces, solvent traps, and the ATF in general. But I think that if we're trying to read the tea leaves as to what happened with this litigation we're going to talk about today, it probably is a very positive sign, especially for those of us who believe that magazine bans are, in fact, unconstitutional. So today, we're going to spend a few very important minutes and talk about how the tide is starting to turn on magazine bans. All right, before we get going down the road we are going down, proud to announce that this video is being sponsored by Legal Heat. That's right, the nation's largest educator of concealed carry classes. Legal Heat, since they started business in 2005, has taught over 200,000 people nationwide. Now listen, for my Washington viewers, you can find a class at any one of these locations right here. For those of you who are watching somewhere else outside the state of Washington, congratulations, you are living freer than we are. You too can find a class right close to your backyard by visiting them at mylegalheat.com. That's mylegalheat.com. Now listen, for any of you, no matter where you're watching, if you use the promo code Washington Gun Law, that is Washington Gun Law, all one word, find a class you like, you will get 10% off. So for more information, visit them at mylegalheat.com. Okay, so the issue we're talking about today is Heller versus District of Columbia. You're like, whoa, wait a second. Why are we talking about a case that's more than a decade old? Oh, no. I'm talking about a new Heller versus District of Columbia. You see, the Heller Foundation, that's right, that particular Heller, sued the District of Columbia claiming that their municipal ordinance, which restricted how much ammunition a person could carry with them, those that had actually been granted concealed carry license, so the 1 in 1,000 that the District of Columbia is willing to bestow with the privilege of a concealed carry license, but they had an additional municipal statute that said, listen, you can only carry enough ammunition to reload the firearm twice. However, it is capped at 20 rounds. So essentially, no matter what the capacity of your firearm was, you could not carry more than 20 rounds of ammunition. Now, back in June of this year, the Heller Foundation, that's right, that particular Heller, filed suit against the District of Columbia. And the statute that they were suing over was District of Columbia Municipal Regulation 2343.1, which reads as follows: a person issued a concealed carry license by the chief while carrying the pistol shall not carry more ammunition than is required to fully load the pistol twice, and in no event shall that amount be greater than 20 rounds of ammunition. Now, of course, this was in reaction to the very clear holdings that came down in New York Pistol and Rifle Association v. Bruin, which really puts all of these crazy gun control pieces of legislation on notice that, hey, listen, if we're going to analyze these laws through the correct constitutional analysis, many of them are going to be struck down. Now, I should have said earlier that the law doesn't read that way. It read that way because as soon as Heller filed suit, the District of Columbia moved to amend the statute. That's right. They were actually willing to change the statute. It's one of those, oh crap, we're getting sued. We need to change the statute, which, by the way, the state of New York also did in Bruin and then tried to argue to the United States Supreme Court that the issue was now moot because they had changed the statute. They hadn't changed it much, but they changed it enough where they thought they could get away with killing the argument. It didn't work for them. And as a matter of fact, when the District of Columbia did decide to change the regulation, they filed notice with the Heller Foundation, the plaintiffs in this case. The notice stated, defendants provide the attached notice of emergency and proposed rulemaking by the Metropolitan Police Department, promulgated on September 14, 2022, see Exhibit A. Notice of emergency and proposed rulemaking. It was effective immediately on signature and will be published in the September 23, 2022 edition of the D.C. Register. The notice repeals the ammunition limit challenged here. So it really was one of these, oh crap, we're probably going to lose this thing, let's change the law. Now, What did the District of Columbia do with this lawsuit? Well, they have asked the Heller Foundation to join them in a stay of proceedings so they can find a settlement to this suit. Because see, what Heller was claiming is, hey, listen, this law violates my constitutional right. What the District of Columbia now wants to do is settle this case, because what they don't want is a published opinion once again announcing how this law was unconstitutional. In fact, the proposed settlement agreement from the parties states, plaintiffs Dick Anthony Heller, Charles W. Nesby, and the Heller Foundation, and the defendants District of Columbia and Robert Conti, Chief of Metropolitan Police Department, collectively the parties, jointly move to stay this litigation until October 17, 2022. The parties are discussing settlement and need additional time to pursue a potential resolution that would avoid further litigation. To facilitate these efforts, the parties request that the court stay this matter until October 17, 2022, and order the parties to submit a joint status report by October 17, 2022, updating the court on the status of any settlement negotiations and whether a further stay of proceedings is warranted. So, essentially, the parties are saying, hey, give us some time. We don't think we need to litigate this anymore. We believe that the District of Columbia is willing to settle this suit. Now, here's the thing. There is a statute which has been repealed now by a new statute, which limited the amount of ammunition that a person can carry. However, and this is important, the District of Columbia also has a separate statute which limits the capacity of magazines. That statute, Section 7-2506.1 specifically reads, no person in the district shall possess, sell, or transfer any large capacity ammunition loading device regardless of whether the device is attached to the firearm. For purposes of this subsection, the term large capacity ammunition feeding device means a magazine, belt, drum, feed strip, or similar device that has a capacity of or that can be readily restored or converted to accept more than 10 rounds of ammunition. So as you can see, the District of Columbia has a statute that's somewhat similar to Washington State. Washington State does not, at the current time, limit the possession of large capacity magazines, as they call it, but it does restrict the commercial sale and purchasing of those magazines. But listen, if the District of Columbia is willing to concede that their statute, which limits the number of rounds a person can carry in defense of themselves, is unconstitutional, how then can a statute which limits the number of rounds that a person carries be found constitutional? And that, my friends, is exactly what a magazine ban does. Let us remember, under the very clear holdings of New York Pistol and Rifle Association v. Bruin, we do not engage in that second part of a balancing test where we're going to weigh societal interest versus the individual rights and the infringements thereupon. No, instead we're going to take a look at, does this legislation infringe upon the type of activity traditionally protected by the Second Amendment, with a special emphasis on the text and history. The first magazine ban in the entire nation occurred in what state? Oh, of course, California in 1989. That, my friends, is not a rich history of restricting magazines. The District of Columbia, one of the most anti-gun, anti-Second Amendment government entities known to man, has already begun to crumble under the pressure of the Second Amendment. They have decided that their ammunition ban is unconstitutional, and we believe with another suit that will assuredly be coming, they will have to make the same conclusion and announcement as it relates to their magazine ban. So once again, that case is Heller versus District of Columbia, the one that was filed June 30th, 2022. And then, of course, remember, we all need to pay very careful attention to Duncan v. Bonta, the California magazine ban case, which was GVR'd by the United States Supreme Court, sent to the Ninth Circuit. The Ninth Circuit has since sent that down to Judge Benitez, who ruled in favor of Duncan originally. We are awaiting a ruling there. It is highly likely that we could see an end to magazine bans in the Ninth Circuit before the end of the calendar year. Listen, we'll put a link for all of those cases and all of this information down below in the description box. If you have any other questions about magazine bans or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, Part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.